Welcome. We're coming back now. I'm Aoife White, the Technology and Competition Editor for Politico, and we're going to talk about the Digital Markets Act. We have several fine panellists speaking to you today. We have Alberto Bacchiega, who's going to be the Director of Digital Platforms at the Commission's DG Competition. We have Vanessa Turner, who's a Senior Advisor for Competition at BEUC, the European Consumers Association. Here comes Alberto, now you can cheer. And last and very much not least, Kay Jabelli, Competition and Regulatory Counsel at CCIA Europe, who represents most of, in whatever order you like. We're just glad to have you here. Thank you. So please take a seat.
Thank you.
And Kay represents most of the tech industry, so he has an awful lot to tell us. But I'm going to start with Alberto. Alberto, we have a lot of deadlines coming up, and there's a lot to expect of how the DMA is going to roll out. What can we expect in the next few weeks and months? Can you tell us how implementation is going forward?
Yeah, sure. The first important date to note down is actually coming up Tuesday next week. 2nd of May is the day in which the DMA will become applicable. Which will also, and then it triggers a series of periods that are all very important. So with applicability, gatekeepers will have 2 months to notify their core platform services. So that we get to very early July, and they can notify at any point in time within with these 2 months. It will not be a decision of the Commission when they notify. We expect more towards the end of the period rather than at the beginning. Notification triggers a 45 working days period for the Commission to actually take the decisions on designation. And there we get to early September if they notify early July. And then our decision triggers a 6 months period for compliance. And compliance is actually what matters here. We get to spring 2024, and that's when actually the designated gatekeepers will have to comply with all the provisions in the DMA. So lots of deadlines, what businesses and consumers should start seeing, the real changes, they should become apparent from March next year, basically.
And how ready are you, and how ready do you think the industry is for this? I mean, we've seen appointments to the task forces. Do you feel, are you staffed up the way you'd like to be? Do you expect to see more people come in?
Yeah, that's, never ask a bureaucrat or a Eurocrat if they're staffed up to the level they would like to see, of course. That's never the case. The question is, we have a group of people. I think I have a group of people together with the colleagues in DG Connect. We have a group of people that can work on the issue. We are 40 on DG Com side, and DG Connect is gearing up to have a similar number of people. So we will. That's what we have. Resources in the Commission are not easy to mobilize, as you probably know. Member states are not too keen on expanding the payroll of the Commission, so we have to work with what we have. I'm quite pleased with the group I have. If I could have the double, I would be much more pleased, but I think we have enough people to do the job, or at least to start doing the job. And there are also many unknowns that we will need to consider to see what the needs are. If you think we will designate companies in September, but how much litigation we will have after September? How many of the gatekeepers will disagree with our decision and take us to court? That, of course, it's a question mark. How many rebuttals requests will we receive? The gatekeepers that meet the thresholds, but they say, well, notwithstanding me meeting the threshold, I'm actually a false positive. I'm not really a gatekeeper. And then on that would, in many cases, trigger on our side a market investigation. So that also we need to see how much workload that is. Compliance discussion and work will be very, very big. And finally, also for core platform services that don't meet the thresholds, we will have the possibility to start a market investigation for the so-called qualitative designation. So between now and September, the work is cut out. It's quite a lot. From September on, it's going to be even more, and to some extent, we will need to adapt to what the market reality is.
I mean, one thing we've seen so far are the workshops where we've had the possibility for the wider tech industry and other interested parties to engage with you. What do you expect more workshops? I mean, how ready do you think everybody is, apart from you, for this for the next few months?
I think companies have been investing a lot in it. That's quite clear. How ready they are, it comes at different level. How ready they are to interact with us, it varies. Some companies have been more forthcoming than others. You see, they also have a different view of what the DMA will bring from them and how they want to interact with the Commission. How ready they are to actually do the changes they need to do in their system and business models to comply with the DMA. That is a very difficult question to answer from me. That's probably the industry knows better. On the workshop questions, we've had 3. We will have a 4th one on the 5th of May, Friday. It's open to everybody. It's going to be on data-related obligations. So it will follow the same format as the others. So bringing together potential gatekeepers, interested business, consumer associations to discuss in very, very practical terms what compliance should look like.
Vanessa, I mean, consumers have always, BEUC especially, has always had a great deal of interest in the digital competition cases. Do you feel you've been involved enough? How do you think you'd like to see the back and forth between the Commission and the gatekeepers work? What place should you have?
It's a very good question, and I think a very important question. From the European consumer perspective, we're very happy with the existence of the DMA and the fact that it's on the statute books, but it will be really important how it's actually implemented. And I think there's 2 interesting points in particular on the implementation. One, we're talking about sectoral ex-ante regulation, which is different to kind of competition law, which has been the traditional focus for the cases that you just mentioned. And I think that requires a different approach from the Commission, and maybe the workshops are part of this. We're talking about trying, from the consumer perspective, what we want is the DMA to operate from as you said, from March 2024, when the obligations come into force, and we want them to operate properly at that point. So it seems to us that it's really important that the Commission talk to industry, whether it's the gatekeepers or the others or third parties, and gives the gatekeepers guidance so we do actually get ex-ante rules in force, rather than having to correct them ex post, as is the way that happens under competition law, which was one of the problems that led to the DMA in the first place. So that's kind of one angle which I think is really important, that there be upfront guidance so gatekeepers can comply from day one. But then the second point, and then coming to the specific involvement of consumers, is, there is clearly a huge information asymmetry between gatekeepers and the regulators. And I think third parties, consumers and business users, can actually help minimize that information asymmetry by being involved in the discussion on the implementation of the obligations. But that also requires timely involvement, and it requires that third parties, whether it's business users, people who are using platforms, or consumers, have sufficient information to actually make meaningful comments to say, yes, this works, or that is not going to work in reality. So I think that's really important for third parties to be involved in that way. Through the workshops we have been involved in all the workshops so far, but I think that's only the beginning. It's certainly not the end. We need to look at the details.
Okay, this is not just a process for the gatekeepers and the Commission. How do you see the wider digital economy in this? How do you see it important to draw in other companies or to draw in the needs of the tech industry?
Yeah, and of course I need to preface by saying that I'm not speaking on behalf of any particular company, but CCI Europe as an industry-wide group. I would, in terms of how the wider digital economy is going to be thinking about this as well, I want to echo actually what Vanessa said about the importance of good dialogue, which the workshops are a good example of that, and guidance. I think this is going to be a big change in the digital landscape in Europe. there's going to be a lot of room for mistakes, unfortunately, and we've also come out and asked that there be more resources to really be able to get into the weeds on this stuff. And again, the workshops are a great part of that, getting into the technical details. I don't know if anyone in the room has been following those, but some of those discussions have gone to I'm an engineer myself before doing this, and even for me, we're quite informative and challenging. So I think that's a great posture to be taking. And I think what we've seen already recently with the way the market has been developing, this morning we were all just talking about ChatGPT, which has been on the market for just a couple of months. Since the time that the regulation was first written, Zoom has become a verb, TikTok has been grabbing increasing headlines and even being banned in some circumstances. And so the markets have already been changing a lot more than since the regulation was first written. And I think we need to be able to have a regulatory apparatus that is able to adapt to this and continue to evolve alongside these markets, so that we don't end up actually inadvertently distorting fair markets and contestability in markets and with rules that are too rigid.
Do you think that companies are getting the information they need, the access they need to discuss through these issues?
I think it's hard to see how it's going to work out. This is a new regime, so obviously it's a learning process for everyone, both for companies and I think for Alberto and his teams and the wider Commission. And so we all want this to work. And we need to figure out, what doors need to be open and which ones not open in order to make it work.
Alberto, you've talked about compliance reports, and I understand that the idea is to publish these. What kind of level of detail would we see in these? How quickly would we see these?
So the first compliance reports need to come at the same time as compliance. So that will be March 2024. That, of course, the content of the reports will be part of the dialogue with the gatekeepers, but what we would like to see in the public version of the reports, which in the DMA is a summary, but we would like to see a complete document that is understandable by the public who is interested. So one thing we wouldn't want to see is a heavily deleted and completely unreadable version of a report that only the Commission would receive. And we would like the gatekeepers to explain clearly what solution they've chosen, why they've chosen this solution, why they discarded other solution to comply, and actually what they have done to check internally, but also with with their business partners, with the end users, that these solutions work. So we place a lot of importance in the compliance reports, and also we encourage gatekeepers not to think their compliance solution in isolation or just in bilateral discussion with us, but to reach out to their stakeholders, to the businesses they interface with, to consumers, to actually test their solution. Because in the DMA, perhaps also another difference with competition enforcement, where you impose or you agree remedies and then it's fixed, and it's whether we got it right, it works, we got it wrong, it doesn't work as well. In the DMA, we will be regulating these companies over and over again. And the compliance report is a yearly report, it's not a one-off. And the compliance solutions need to work. The DMA requires a result to be achieved. So if something doesn't work, we will need to change it again. So it's much better actually to figure out something that works from the start than to figure out something that is half-cooked, that will raise complaints or a reservation from the public, that will require the Commission to decide whether we can adjust or whether we need to sanction. But it would be much easier to actually find a solution that works for the public at large.
Vanessa, do you have any concerns or requests about how either the compliance reports would work and how soon they'd come out, and remedies testing?
Yes, I mean, I'm very encouraged to hear what Alberto says in terms of the level of detail. I think it is going to be really important that people, whether they're engineers, not necessarily so much lawyers, but engineers or technical people, or even behavioural scientists, can understand what has been done by way of compliance. And one of the things that we care about is making sure that compliance is not just with the letter of the law, but is effective. And there are many ways you can ostensibly comply with the letter of the law, but then change the user interface, use of dark patterns, which we see used heavily online, to try and actually influence consumers to do something different than what the DMA was intending. So it'd be important, for example, you mentioned in the reporting that I think that if gatekeepers are doing A/B testing of their user interfaces, for example, that data be included in the compliance report, or enough of it to see how actually why things have been done in one way rather than another, because we have seen issues with user interfaces, for example, in other cases, in competition cases, where the design of the remedy actually might have made it much less effective than was intended by the regulator imposing it. So that kind of level of detail needs to be there to make sure any implementation and then later any remedy is effective in reality.
What level of discussion would you want to be in on designing the remedy? I mean, this is something that in competition cases hasn't happened.
I mean, in competition cases, it depends. I mean, in merger cases, there is I mean, it's quite interesting. In merger cases, there's quite detailed consultations on remedies, and on commitment cases, there are quite detailed consultations on remedies, not on prohibition cases. So I hope we're going to go, to the extent we are following those kind of processes at all, and bearing in mind this is sectoral regulation, not competition law, then I think it is really important to be involved right at the beginning, so that any things can be put in the right direction, so we are effective in March 2024, and it doesn't require whole compliance or non-compliance proceedings down the line, because that would undermine the kind of the essence of the DMA to have ex-ante compliance. So I think it does need involvement of technical specialists and users from day one, subject to confidentiality, obviously.
Okay, how do your members see this process? I mean, do they see it as something burdensome or helpful? I mean, what kind of level of detail? I mean, I understand you probably hear a range of views, but could you give us a flavour of what people are saying?
I think there is definitely an acknowledgement amongst the wider industry that this is a change in the way that platforms are going to be governed, their relationships with the market, with their business users, with their customers, and with the government. And this is acknowledged to a large extent, and obviously there's differences between the members, and some are showing themselves to be more engaged than others. Talking about my observations from the industry at large, but the Commission has for a while already said that there's an open door, and been very much giving companies that opportunity to be able to speak, and I think that's important, and look forward to it continuing. We were talking about information asymmetries before, and this open exchange and discussion also with third parties is really important to help address those issues and make sure that the rules that are ultimately going to be applied, and the obligations as they're enforced, and the changes. I mean, it's not just about the rules, but it's really about the changes to the products that is going to happen. And I think everyone acknowledges that these products will be changed in Europe, that those work for business users, for consumers, and really achieve the objectives of the DMA.
Are there concerns among members that the system can be gamed in some ways? I mean, we already, this is a very rich ecosystem, and a lot of companies have different vested interests in how they see things.
Yeah, I think there's always those concerns, whether you're talking about in competition cases or in the future. Again, this is new, and optimistically, it'll work effectively, and the views that are more about trying to gain an upper hand, or as we sometimes say, rent-seeking kind of views, self-interested views. The Commission has a lot of experience dealing with that in competition cases. Hearing from competitors who are interested in getting an outcome that is for their benefit and not for the wider public. and understanding where those are coming from and taking the good bits and rejecting the bad bits. And I think we all need to work together to ensure that the DMA, the approach in the DMA and the enforcement of the DMA takes a similar approach.
And national authorities may have some kind of role in the DMA. Is that a concern for you?
Yeah, I think on the national authorities' role, it's probably less of a concern about their role on the DMA itself. I think they have a lot of experience. They have, sort of say, boots on the ground as well. So they're well placed to support the Commission, and I think that is the right role as ascribed by the law for the DMA. But the DMA was also a response to regulatory fragmentation. Rules that have popped up and now are live and being enforced in various member states, and I think there is a concern across industry that is kind of defeats the purpose of the DMA. It's going to lead to regulatory fragmentation. You're going to have different rules being applied in different jurisdictions. That these companies won't know that they can design a product a certain way that will be compliant, and then they can deploy that across Europe, and that they won't suffer liability, whether it's from private damages claims, whether it's from national competition enforcement or other enforcement and national rules. And I think that would be a real shame, because if the DMA is not there to really help guide the way these products are being developed in Europe to meet European objectives, then I think we've kind of missed the point a little bit.
Alberto, what do you do to try and prevent this kind of regulatory fragmentation?
But I mean, the very first thing that the European institutions have done to avoid that is the DMA itself. It's in the very nature and the reason of existence of the DMA is indeed to bring harmonization of law and to avoid fragmentation. The DMA, has been, the text is there, it's applicable from Tuesday next week. So that's, so far we haven't yet seen that effect of the DMA, but the DMA is extremely clear that the sole enforcer is the Commission, and that national authorities cannot take action that would basically frustrate what the goals and the provisions are for the DMA. So the question will not be about competing for doing the same. That would be absolutely detrimental for the internal market, even before for the companies affected, but it will be about complementarity. And that's what we are working on. That's what we are working on with member states, is to achieve complementarity. The DMA is a very targeted instrument. It only applies to companies that are very large, with a closed list of core platform services, 10 of them, and with a closed list of obligations and prohibitions, 20 odd of them. So there is still scope outside the DMA for antitrust enforcement at European level, at national level, and also for regulatory initiatives at national level. So what we will do is what we've been doing for many, many years in antitrust coordination, is to have a very open dialogue with our colleagues in the member states, and to coordinate our actions and to avoid that we do things twice. Honestly, we don't have the resources to do things twice. There is so much work, to do that I don't think anyone has much appetite to duplicate things.
I've got a question for all of you, but I'm going to start it with Vanessa. What is success? If we're to go 3 to 4 years in the future, what should the DMA have achieved?
I think from the consumer perspective, more innovation and more choice. That would be the kind of the headlines from the consumer perspective. Now, how you work out the metrics of that, I can leave that to some experts, but I think we will see it in the market if it works. If there are more products and more innovative new products coming onto market from different sources, that would be success. I think another part of success, touching on some of the things that were being discussed this morning in relation to other bits of legislation, is that the DMA is also future-proof, because as we've seen, things are moving on very fast in the digital world, so that would be another measure, a different measure of success, but I think an important metric as well.
And to ask the same question in a slightly different way, what would be a failure? What if things went wrong? How would we be disappointed if we're back here in 4 years' time?
No change on the ground. Yeah, there's no point in having a beautiful law if it's not actually implemented. So the implementation to me will be absolutely key, and making a success of that, and giving the Commission the resources it needs to make that happen, and all the other things that we've already talked about.
Okay, what is success for the tech industry out of this rather grueling process?
Yeah.
Surviving.
Well, I wouldn't say it needs to be that bleak. I think the opportunity is there for the DMA to increase innovation, and really I think that can help be achieved if we go back to kind of what the DMA was tagged at and sometimes summarized as giving clear do's and don'ts. I think there's a lot of importance there on the do's. Clearly knowing what companies can do and being able to make investment decisions on that and deploy those resources into developing new technologies that they know aren't going to give rise to various kinds of legal liability in the future.
And if it was a failure, what would that failure look like?
Yeah, it's the other side of the coin there. Just that uncertainty that would depress investment, that would create fragmentation and really prevent Europe from achieving its digital ambitions as quickly as possible.
I mean, this is a cruel question for you, but I mean, what is success for you, and what frustrations would you see if you didn't get quite where you wanted to be?
But I think there are various elements on the let's say not immediate, but in the medium term, I totally agree with Vanessa. I think success, if we have some very tangible changes that businesses can see, that businesses, I mean, not the gatekeepers themselves maybe, but the dozens, hundreds, thousands of other businesses that are digital companies that have good ideas, that they see that they can bring them to market and to consumers in a easier way. So, and of course, if we see no change, I also agree with Vanessa, if consumers will see no change, if businesses will tell us it's exactly the same as it used to be, that will be our failure. I think the ambition more in the medium to long term is to know that the challenger to the positions that are now rather entrenched in the market from the platform, because they can enjoy all what we know about economy of scale, use of data, network effects, that these challengers will feel emboldened to actually challenge, that that the companies with an innovative ideas will not come to market thinking, I need either to be bought by one of the giant tech companies, or I need to adapt my idea to that ecosystem, because otherwise I will never make it. That they will be able actually to challenge this position. What the DMA cannot do is to undo the positions that came about in the last 30 years of history. It's not the role of regulation. If there is something that has been achieved legally, very good, it's the entrepreneurship that is being rewarded. If it's not been achieved legally, it's not for regulation to tackle the issues, it's for antitrust enforcement to tackle the issue of the past. But for the future, it's quite literally to achieve the objectives of contestability that is hard written in the DMA.
Would it concern you if companies were not rolling out certain services in Europe because they were worried about the compliance costs or difficulty?
Of course, I mean, everything we do is we want to do it for the benefit of consumers. Not rolling out service in Europe, could be either because we are over-regulating and we are imposing something that makes uneconomical the rollout of this service in Europe, could be a tactical move as well. So I would like to see why certain things are not happening in Europe. I don't think the DMA is killing any business model. It's just requiring business models to adapt, and mostly is requiring gatekeepers to be more open and to give more choice. We are not asking any gatekeeper to shut down any of their services. We are just asking gatekeepers very often, alongside the service or the integrated service you bring, you allow someone else to make their own proposition. And then the better one will be the one that will pick up the likes from the consumers.
In the last few years, we've seen a huge amount of regulation coming through. Data Act is still to come, possibly in the next couple of months. The DSA we saw yesterday. We saw a UK digital competition bill yesterday. There's a lot of different moving pieces. Vanessa, do you have any concerns about how those things interact?
I think I have a question mark on something that I hope that people are looking at. And you're right. I mean, we heard about the Data Act today. We heard about the AI Act today. There's lots of other legislation, whether it's within the EU or at national level as well, or internationally. But I mean, coming back to the EU level, I think there are touch points between different bits of legislation. So, for example, on things like access to data, we heard about the Data Act just now, those who were in the room, but there is also access to data under the DMA. So it strikes me that it would be important to ensure that all the various bits of legislation work as a consistent and coherent whole for business and also to have their intended effect. And for much of the other legislation, the primary enforcer won't be the Commission, but will be the national authority. So I think it'll be for them to work out how they make sure that this actually interacts properly. And there are other touch points that I haven't mentioned, but that do exist. I think the Commission could play a role. I mean, taking it from looking at the consumer space, we have the Consumer Protection Cooperation Network, where the Commission kind of plays a role in coordinating pan-European enforcement in the consumer space. But you could look at a role for kind of digital regulation to make sure that these pieces of legislation are each achieving their purpose without impinging on one another, and actually to create a coherent and consistent regulatory landscape.
Okay, how do you see companies negotiating this? I mean, it is a very complicated landscape.
Yeah, I say, I think it's fairly clear that the so-called digital Wild West is over, if it was ever there to begin with. But the concept of a Wild West, we've all seen these spaghetti Western movies and stuff. There's also this undercurrent of opportunity. And from a private sector point of view, I think it's important that all this regulation doesn't take away opportunity for businesses to create value for their users, and for the economy, which is creates jobs, it creates new innovations that people benefit from, and I think that's where the devil is in the details, and we'll have to see where the rubber meets the road. But I'm sure that industry, people like myself and many people in this room will be doing their best to help the dialogue move forward and try to ensure that those unintended consequences don't happen.
Do you have a response to that? How are you mindful of these things, of interaction and of working with others smoothly?
Of course, very much. I mean, we've been the producers of much of this legislation in the Commission, so there is a level, of course, at the drafting of the legal text to ensure coherence, but there is a lot of dialogue that needs to be going on afterwards. Some of this legislation actually target different domains, so perhaps the same company but very different domains. For me, between the DMA and the DSA, the division of labor is quite clear. For example, content versus type of business behavior. But of course, there are important touching points between the DMA and the GDPR on the data-related provisions. Actually, that's something we will also discuss week after next. Or next week, and we are very mindful. I mean, I think we are to some extent privileged that we have our network of colleagues within the Commission to whom we can always refer to, but also we need to coordinate at national level. And again, the institutions are there. I think DG Competition, we have a bit of tradition with the European Competition Network about this coordination. I don't know, what the audience thinks about how useful it's been. For us, it's been extremely useful, and we need to reproduce that. The last remark is that as an industry comes of age, regulation becomes necessary. And there are always different pieces of regulation that need to interact. In a way, it is complex, it requires a lot of attention, but it's not unheard of. I always think back at the financial regulation about this complexity, about this need to be future-proof, about the continuous chasing, if you want, between market developments and regulation. and all the awareness we need to be, I think we will need to replicate it in the digital sector. I think what is very, very new here is not the concept or the theory of it, is the fact that we are starting now in this specific sector.
Thank you very much. And I'm sure you'll have a very busy summer, so I hope you get a break at some point.
We do.
Thank you, Vanessa. Thank you, Kay.
Thank you.
This is an age of disruption, of profound revolutionary change.
What we're really asking ministers is to empower the ambassadors.
The only thing that you really push forth is the truth.
You don't see many women represented when it comes to the decisions as to how to handle the pandemic.